Good afternoon, everyone. As you might know, my name is Peter Neufeld. I'm a partner at Wagner, Sidlofsky, LLP, and the co-chair of this Lunch and Learn series on strategies, advice, and the elderly, along with my partner, Brad Phillips, who will also be presenting today. I'd like to start us off with a land acknowledgement. We acknowledge that the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse nations, Inuit, and Métis people. We also acknowledge that Toronto was covered by Treaty 13 with the Mississaugas of the Credit. Today is the final seminar of the series for this year. And the subtopic that we are going to be speaking about today is a heavy one. It is on elder abuse. A paper was prepared by Gabriella Verdicchio and Brad Phillips in advance of today's seminar on this topic. And the PDF of the copy of that paper can be found in the Zoom chat. In addition, Marshall Swadron, who's also presenting today, has presented and prepared a paper for today's presentation as well, and that will also be included in the Zoom chat. The certificate of attendance will also be posted there momentarily for you to download, so feel free to check out all three of those documents. The seminar has been approved by LawPro for the Risk Management Credit Program, and it's eligible for a $50 credit claim. It's free money. Go ahead and download that so you can take advantage of that. Thank you to our sponsors, Scotia Wealth Management, the B'nai B'rith, Concentra Trust, Weir Folds, Donovan Kochman, and Torkin Mains. This event is, as always, complimentary because of them. A few housekeeping notes. Please have your microphones muted at all times, unless you're asking questions at the end of the presentations, after which we ask that you mute yourself again. Please also note that this seminar is being recorded. You may have heard that at the beginning of the presentation. Okay, we have three presenters today. It's a packed house. We have Brad Phillips with us. He is a partner at Wagner Sidlofsky LLP, practicing in the estate and commercial litigation groups, and he's a co-chair of the seminar, as I mentioned. He has successfully acted as lead counsel at trials and on appeals before the Ontario Court of Appeal, and has been involved in numerous motions and applications before the Superior Court of Justice. And if you ask me in the bar, he's one of the best. He'll be joined with Marshall Swadron. Marshall is an experienced lawyer who has appeared at every level of court in Ontario, as well as the federal court and the Supreme Court of Canada. His practice includes mental health and capacity law, guardianship and estate litigation. He is frequently appointed by the Public Guardian and Trustee to represent allegedly incapable persons in guardianship matters, with a focus on promoting their autonomy and participation in decision-making. Marshall has over 13 years of teaching experience with the Law Society's lawyer licensing programs, and has authored chapters on the charter and constitutional litigation. But of course, we'll also be joined by Graham Webb. Graham has served as the executive director of ACE, that is the Advocacy Center for the Elderly. He's had that position since October of 2016, following more than 2 decades as a staff litigation lawyer there from 1995 to 2016. Prior to joining ACE, Graham practiced law in Barrie with a focus on civil and criminal litigation, appearing at all levels of the court, including the Supreme Court of Canada, the Ontario Court of Appeal, and the Superior Court of Justice. He also regularly provides legal education on elder law issues to older adults and service providers, including healthcare professionals and lawyers. I could go on, but we do only have an hour here, so I just want to thank all three presenters for being with us today. If you've enjoyed this series so far, we ask that you consider making a donation to the B'nai B'rith if you haven't already. The link for that is in the chat. Maddie will be adding that. We have Cheryl Landy here today. She is the Director of Community Engagement, of B'nai B'rith Canada. She's going to be telling us a little bit about the organization and its charitable work. So go ahead, Cheryl, you have the floor.
Thank you, Peter. Just to reintroduce myself, my name is Cheryl Landy, and I have the privilege of serving as the Director of Community Engagement at B'nai B'rith Canada. For almost 20 years, B'nai B'rith has partnered with Wagner Sidlofsky's CLE program, and we are so deeply grateful for your continued support. You've helped us do work that truly matters, work that changes lives every single day. Over the past months, I've shared stories that show what B'nai B'rith is all about. Our food bank makes sure that seniors don't go hungry. Our housing for seniors gives safety and comfort to those who might otherwise be alone. Our clothing program wraps people in dignity as much as warmth. And our men's group reminds us how much connection and belonging can mean. Last session, I spoke about Tuna Tuesdays, where middle school students collected tuna for our food bank. A simple act that showed how kindness can start at any age. And our women's group, our newest project, helps newcomers rebuild their lives, offering not just clothing, but comfort, confidence, skills, and a sense of hope for the future. Each of these stories reminds me why I love what I do. Because at B'nai B'rith, it's never just about the food or the clothing. It's about that human moment, that spark of dignity, compassion, and hope that says you're not alone. As we wrap up this series, I want to thank you from the bottom of my heart for standing with us. If you'd like to help us keep this work going, please visit bnaibrith.ca/donate. Your generosity can't just save lives, it restores faith, renews hope, and reminds people that kindness still exists. Together, we're not only changing lives, we're building a stronger, kinder Canada, one act of compassion at a time. Thank you very much.
Thank you, Cheryl. Much appreciated. We're going to start with the presentation now. Again, the subtopic for today is elder abuse. Brad Phillips is going to start us off, followed by Marshall Swadron and then Graham Webb. Take it away, Brad.
Thanks, Peter. As Peter mentioned, we are ending our seminar series on a rather heavy note, with our topic today being elder abuse. But it's an important subject given that it is a pervasive issue in Canada. Elder abuse affects between 4 and 10% of older adults in Canada, and the COVID-19 pandemic only exacerbated many of these pre-existing issues. So what is elder abuse? Looking to the courts for a specific definition of the term is a challenge, because to date there are no reported cases in Canada where the court has created or stated their own definition of the term elder abuse. Rather, judges have typically cited certain policies, statutes, or adopted expert definitions in trying to define this very broad subject. In Ontario, there is no consistent definition of elder abuse that exists across all legislation. So this leads to the legislative and judicial branches having to piece together various definitions from different contexts in an attempt to address this issue of uniformly. Now, there have been an attempt to create a global definition, but as you will see, even this definition creates its own issues, and moreover, this definition has not yet been universally adopted. But at least it's a starting point for our discussion today. The Toronto Declaration on the Global Prevention of Elder Abuse, which I'll call the Toronto Declaration, was jointly authored with the World Health Organization, the U of T, and the International Network for the Prevention of Elder Abuse. And it defines elder abuse as follows. It's defined as a single or repeated act or lack of appropriate action occurring within any relationship where there is an expectation of trust, which causes harm or distress to an older person. So, by necessity, the Toronto Declaration and other similar definitions incorporate a broad range of actions or inaction towards an older person within the definition. And this is intended to capture a broad range of conduct, such as physical abuse, financial abuse, sexual abuse, mental abuse, or neglect. Notably, this definition suggests that an elder abuse can occur even in a single instance of an inappropriate act, word, or attitude, or a lack of appropriate action. So its broad definition also is intended to convey that elder abuse can manifest itself in many different ways, and that abuse can occur even without a party having acted or spoken to the older person directly. But perhaps the most difficult terminology of the Toronto Declaration of Elder Abuse is the use of the phrase, any relationship where there is an expectation of trust. So while naturally a great deal of abusive behavior can center upon people who an older person trusts and relies upon, a major criticism of using this trust terminology within this definition is that it lacks the inclusion of frauds and scams where the expectation of trust might not usually be found, even though older people are often targeted. One would be hard-pressed to say that those recent scams that have been reported where AI voices that sound like a grandparent's grandchild are being used to get the grandparents to transfer money to shouldn't meet the definition of elder abuse. But based upon this definition under the Toronto Declaration, it would technically not, given that these scammers or fraudsters do not have a trust relationship with their victims. The other point I want to draw upon is that while clearly financial abuse falls within the definition of elder abuse and is a serious and ongoing issue, it is also a topic that we have covered in several previous Lunch and Learn seminars. So as a result, for the purposes of today's seminar, we're going to focus on other forms of abuse. And what becomes apparent is that these forms of abuse can manifest themselves by active steps being taken by a person towards an elder, or it can manifest itself by a way of deliberate inaction towards that person. So, for example, psychological abuse in the form of violence can manifest itself as emotional blackmail, manipulation, humiliation, insults, belittlement, verbal and nonverbal threats, etc. But in the form of neglect, it can manifest itself as rejection or social isolation, abandonment, disinterest or insensitivity, or not considering the spiritual needs of the person, or not providing conditions that are favorable to exercise one's spirituality. Similarly, physical abuse in the form of violence can manifest itself as shoving, hitting, burning, force feeding, inappropriate use of restraints, whereas in the form of neglect, it can manifest itself as failure to provide a reasonable level of comfort and safety to an elder, failure to provide assistance with eating, grooming, hygiene, or taking medication when the older person is in a situation of dependency. Another category would be sexual abuse in the form of violence that could manifest itself as degrading jokes or remarks of a sexual nature, sexual advances, sexual contact, etc. Whereas in the form of neglect, it could manifest itself as failing to provide privacy, systematically treating older persons as having no sexual attraction to others or lack of desire to have sex, and or preventing them from expressing their sexuality. So the intent of this discussion today is to focus primarily on what lawyers can do to address these challenging types of cases when a client comes to the door and makes allegations that an elder is being exposed to these specific types of abuse that I've just referred to now. And as you will likely hear from both Marshall and Graham, options for immediate assistance by civil litigators to the specific types of abuse we're going to be focusing on today are somewhat limited. And in some cases, police involvement may be needed to be pursued. And the reason why I say that these avenues are somewhat limited is that traditional civil tort remedies, such as claims for battery, or sexual battery or assault or the tort of intentional infliction of mental suffering, while certainly available to victims of elder abuse, are arguably inadequate forms of redress. So, for example, tort law obviously does not impose a criminal record on an abuser. So consequently, it does not prevent an abuser, for example, in a long-term care home, from continuing to practice healthcare in other facilities if there's no criminal record of it. It's also arguable whether damages can adequately compensate for these types of harm, particularly where an older person might lack capacity. So certainly the lack of capacity doesn't preclude an action from being pursued. And in this scenario, under Rule 7.01 of the Rules of Civil Procedure, a litigation guardian must be appointed to pursue a claim on behalf of a person under disability. And under Rule 7.02, there are certain people who are automatically, and in fact are presumed that they should be acting as litigation guardian for a plaintiff or applicant under disability without a court order. And these would include a guardian for a party that is mentally incapable, or a attorney for care if the plaintiff or the applicant is mentally incapable. And if no proper person is willing to act, the office of the Public Guardian and Trustee may be appointed by the court to act in this role. And when a person is represented by a litigation guardian in relation to a claim, the litigation guardian assumes the role of the person with the claim for the purposes of the legal proceeding. The case of Bentley and Maplewood Seniors Care Society is a sad but an interesting one in that it reflects the type of complexities that can arise in an elder abuse case. So in the case, the family of an 83-year-old woman with late-stage Alzheimer's disease sought a declaration that Maplewood Seniors Care Society had committed battery by providing her with food and liquids. The family's argument was that the woman, at a time she was competent in 1991, wrote a statement of wishes in which the woman had expressed that she did not want to receive nourishment or liquids if she were to suffer from an extreme disability with no expectation of recovery. The lower court's decision, which the Court of Appeal ultimately upheld, suggested that based upon a later document the woman signed, that this 1991 document did not necessarily reflect her intentions. And further, the court specifically determined that the woman's action of opening her mouth to accept food and water constituted consent to the respondent's actions. And consequently, the court found that, quote, such consent is a complete defense to the very technical battery that might otherwise exist. And while I earlier stated that tort remedies may not be a suitable redress for victims of elder abuse because, frankly, damages doesn't really address the more pressing concern of an ongoing issue of elder abuse, it is also within such civil proceedings that other interim and permanent relief can potentially be sought. And that may be of greater practical assistance to an abused elder than the ultimate relief that could be granted in an action for these types of remedies. And I'll now turn it over to Marshall to talk about this issue in greater detail.
Thank you very much, Brad. And it is an honor to be here. I wanted to bring folks' attention to the written material. So there's a comprehensive paper giving us some definitions that Brad has gone through, but I just wanted to shout out to Gabby Verdicchio for having done the work together with Brad. And I want to bring some attention to the paper that we have also provided. It made its debut at the Estates and Trust Summit, but it is apt for today's topic. So this talks about social isolation in particular as a form of elder abuse. And the topic is aptly who decides who gets to see grandma. And it speaks to the statutory obligation that's placed on attorneys and guardians to ensure regular contact with supportive family and friends. And then it speaks to different residential settings in which an elder person may find themselves, and speaks to sometimes the restrictions that are placed on even visitors, sometimes even attorneys and guardians by those facilities, and their authority to do so, and speaks to remedies when those kinds of situations arise. A very good entry into the discussion of access to an older adult is contained in the first scenario that is in Brad and Gabby's paper. So this speaks to, well, we can talk first about our protagonist. The older adult, her name is Eleanor, and she is 85, and she has been found incapable, and she requires care, which she receives in her home. Her attorney for personal care is Jeremy. He is her adult grandson. And although he lives nearby, he is finding the role of attorney for personal care to be onerous. And it seems that the less he has to do, the better for him. And the person that approaches you seeking assistance is an adult niece of Eleanor. She doesn't have a name in the story, but you can imagine that she's a supportive and a person that is a big part of Eleanor's life. She visits at least weekly. She visits as often as Jeremy will let her visit. But soon in the story, Jeremy starts restricting access, and he doesn't tell the niece, your potential client, that he's doing this. He simply seems to have an excuse every time. That Eleanor is under the weather today, Eleanor has too many appointments, different kinds of excuses are coming. And after a couple of weeks, the niece comes to you and says, please do something. I worry that I'm slowly but surely having my access curtailed. And the first option that is suggested in this scenario is that she comes to you and asks you to write a letter. And often a letter or a phone call, these kinds of things can make a difference. It's ideal if Jeremy, the attorney, actually has counsel. So if your letter inspires Jeremy to get a lawyer who then tells him his responsibilities, his statutory obligation to ensure access, and this is a statutory obligation not only placed on attorneys for personal care, but also attorneys for property, that usually this gets things straightened around. So encourage him in the letter to please seek counsel so that he understands his obligations and knows that he can't, he really doesn't have a right to control access. In fact, his obligation is the opposite. The scenario moves forward with the letter not being effective. And the niece says sort of, what is the next step? So sometimes a way to describe the usual form of relief that might be pursued here, which would be a guardianship application to remove the grandson as attorney and install a guardian. Sometimes that's called the nuclear option. And it's a way to look at it because it can lead to tremendous disruption, and it becomes an all or nothing litigation scenario where the applicant faces cost risks, where the stakes just become really high. So short of that, there are remedies in the Substitute Decisions Act. So there's the ability to bring an application for directions under Section 68 of the Substitute Decisions Act. Now, that is not universally available. In fact, at first instance, the niece would not fall into the category of persons that would have standing to bring that application, but the court can grant standing to any other person that the court deems fit in Section 68. So that would be a way to try to correct an attorney if a court remedy is sought. There are also circumstances in which the public guardian and trustee can be asked to intervene. So both in respect of serious adverse effects to property under Section 27 of the Substitute Decisions Act, or in Section 62 of the Substitute Decisions Act in respect to personal care, where there is where the threshold of serious adverse effects that's in the legislation are met, the PGT is obliged to carry out an investigation. So one would hope that matters do not rise to that extent in either case. But, here we have a scenario where, there don't seem to be there doesn't seem to be a person who is naturally in a position to assist and to straighten things out. The substitute decision maker here is an attorney for property who's a grandson, not a child. And it looks like his aunt is sort of the next frequent visiting person.
Marshall, may I speak to that scenario as well from the point of view of Eleanor?
And that's welcome. Thank you.
Okay, thanks. So I'm Graham Webb. As you know, I'm the executive director of the Advocacy Center for the Elderly. I've been here for 30 years. And through my eyes, I see this in a different context because we only act for the older adult whose rights are an issue. So unlike Marshall, who's been approached by the niece, I'm imagining that our clinic is being called by Eleanor. And, long story short, when I look at the fact scenario, it tells me that Eleanor lives in her own home, which is a very good thing because she should have control over who she brings into her home, including a lawyer for legal advice. And the second statement says that Eleanor has been formally assessed as incapable. And that suggests to me that Eleanor has undergone an assessment of capacity for her capacity to manage finances under the Substitute Decisions Act, which is a legally conclusive finding. But it doesn't say that what she's been assessed for. There is no similar legally conclusive finding of capacity for personal care decisions. If it's brought before the court, that's a decision for the court to make. It's a finding of law as to whether Eleanor is or is not incapable of personal care decision making. She's given Jeremy a power of attorney for personal care. And unfortunately, one of the aspects of personal care decision making is that the power of attorney for personal care only becomes effective if and when the grantor is incapable of making their own personal care decisions. That's a good thing. The bad thing is that it's the attorney for personal care who decides whether or not the person is incapable of making their own personal care decisions, and there's no formal appeal process. And I think that one reason there's no formal appeal process is because there's also two other levels of capacity at issue, besides capacity to manage finances and capacity to make personal care decisions, which is the capacity to give or revoke a power of attorney for property, which is a different test, and the capacity to give or revoke a power of attorney for personal care, which is yet a different test. And the Substitute Decisions Act is explicit that even if someone is incapable of managing property, they can still be mentally capable of giving or revoking a power of attorney for property. And even if a person is mentally incapable of managing property, say they've been through a formal capacity assessment and have been found incapable of property management, and even if they're mentally incapable of giving or revoking a power of attorney for property, and even if they're mentally incapable of making their own personal care decisions, that very same person may meet the legal test of capacity to give or revoke a power of attorney for personal care. So if I'm approached by Eleanor and she tells me that her grandson Jeremy is making personal care decisions in her life that she doesn't want, then the issue we're going to discuss with her is whether she wants that POA to continue, because it's often very likely that Eleanor would have the mental capacity to give or revoke a power of attorney for personal care. And if she would like to see us and receives advice and her instructions are to revoke, then we'll help her to revoke the power of attorney. The more difficult aspect would be living in the home if the home is not her own home. If she's living under the care and control of Jeremy, who denies access, that's a whole other ball of wax, and perhaps I'll park that just for the time being in the interest of time.
So if I can pick up on the last point, let's say Jeremy does control access to Eleanor's home. I think that it's got to be clear, and we've as we've set out in the second paper on who gets to see who decides who sees grandma. The only ground on which access might be purposely restricted would be on the ground of safety. So among the different spheres of personal care decision making, safety is the one that might be implicated if there were a history. And to be clear, that's only in the event that Eleanor is not able to make these decisions herself. So if she is incapable in respect of safety, and it is appropriate on grounds of safety to restrict access, that would be the only justification. There's no indication in our fact scenario that that's present. And I want to take things just one level further, because I've had to deal with it in a couple of cases in the last year, which is attorneys for personal care actually taking the grantor of the power of attorney and hiding them. So they could be anywhere, and the other family members just don't know where they are. So this is not just restricting access, but taking them out of their community, putting them in a place where they're essentially having their liberty restricted because they can't access the people to whom are there are other important people in their family, and significant remedy there that has come in handy is actually habeas corpus. So the Habeas Corpus Act in Ontario can require a person who is carrying out this kind of restriction of liberty to account for the person, and sometimes be required to bring them in front of the court, or at the very least disclose their location so that other supportive family members and friends can get access again. So that is where I would stop on this scenario and hand over to Graham in any event.
Well, Marshall, there's a question in the box from Rosie. Could it be a formal capacity assessment for, could it be a formal capacity assessment for personal assistance services under the Healthcare Consent Act? And would that have any significance for this scenario? And the answer is categorically no, because it's not a capacity assessment under the HCCA, the Healthcare Consent Act. It's an evaluation of capacity for two purposes. One would be evaluation of capacity to make a decision about admission to long-term care, and the other would be an evaluation of capacity for capacity to make decisions about personal assistance services within a long-term care home. There's the ability by regulation for the government to expand the scope of that, but at present, substitute decision-making for personal assistance services without the benefit of a power of attorney or a court-appointed guardianship only applies to residents of long-term care homes, so it doesn't apply. Marshall, you're suggesting I introduce the second scenario?
As you wish.
Okay. I actually had thought that uh, uh, that Brad might be doing this, but I'm happy to do it. So things have progressed, and Eleanor, in the first scenario, it was noted that Eleanor had mobility issues, and she was assessed as mentally incapable, I presume, of property. But now her care needs have advanced, and she's being moved into a long-term care home, and she's showing signs of dementia. Which, by the way, um, signs of dementia does not necessarily mean mental incapacity, because capacity is not a medical diagnosis. Someone could have early stage dementia and still be able to understand information and appreciate consequences to the extent that they're quite able to make personal care decisions or even property decisions. In this case, we know it's not the case for property, but you can have dementia to a certain extent and still be mentally capable of some, if not all, personal care decisions. But now she hasn't had any formal capacity assessment. In this case, your client is Jeremy, and Jeremy is designated as her decision maker. He's not negligent or abusive, and Jeremy is actively involved in Eleanor's care, often visiting Eleanor at the home. And so, one uh, particular problem is that a staff member at the home is being abusive to Eleanor verbally. He's dismissing her. He's belittling her and threatening to leave her in soiled linens if she doesn't comply with his demands. And he often leaves her um, uh, mobility devices out of reach, so she risks falls and lacks independence because of that abuse. Eleanor herself has not reported this abuse to Jeremy or other trusted people because the same staff member is also flirting with Eleanor in a sexual manner. The staff member's behavior is erratic and abusive, shifting from compliments and romantic interventions to verbal and emotional abuse. Eleanor's enjoying the attention from the staff member and fears the staff member will stop engaging with her if she reports the abuse. Eventually, Jeremy finds out about this and finds Eleanor on a visit shaking and deeply upset. Jeremy has never seen Eleanor like this before and makes inquiries. She tells Jeremy about the abuse and tells him she has been having panic attacks, nightmares, not sleeping well, and is thinking of suicide. And despite this, Eleanor begs Jeremy not to tell the home administration because she enjoys the sexual relationship she's having with a staff member. Eleanor is resolute in her position that she only wants Jeremy to stop the verbal and emotional abuse, but she wants to continue the sexual relationship. And here, your client is Jeremy. And at this point, I'm actually going to turn it back to Marshall because we don't represent Jeremy's. We represent Eleanor's.
Well, I'm happy to switch over from niece to attorney. So there is so much wrong in this scenario, but it is not unheard of. What needs to happen is Jeremy has to seek to empower his grandmother. If she is going to have a safe environment, she's going to have to be the first line of defense in monitoring it and appreciating the boundary violations that are going on, appreciating that a staff member is absolutely a person in a position of trust. It seems to have acquired greater control over Eleanor by abusing that trust in terms of not initially in terms of mistreatment and sort of keeping her walker out of reach, etc. And then sort of turns this into an opportunity to abuse her in other ways. There are certain there are certain categories of relationships, and this is one where it's a caregiver and a care recipient, that the criminal code exempts as a in terms of limitation periods, and also can creates additional categories or sort of super categories of offenses. So what is going on here is recognized in the criminal law, but the problem is that Eleanor is not going to come forward unless she's empowered to do so and is helped to understand the nature of the conduct, because otherwise, even if Jeremy is going to do the right thing and report to the facility the full extent of the caregiver's conduct, and decides perhaps that he wants to go to the police on his own, it's going to be at the expense of the relationship and the loyalty that he has to Eleanor. So he has to bring her along. If that fails, then he's going to have to make some tough decisions. But regardless, this particular form of behavior has to be stopped, and he's got to sort of do what he has to do, with the assistance of the residents, the police if necessary. That's my view here.
And if I can add in, in Ontario, we do not have a law regarding the mandatory reporting of elder abuse, except in certain limited circumstances. And one of those circumstances is elder abuse within a long-term care home. And under the Fixing Long-Term Care Act, it's a provincial offense for anyone other than the resident to fail to report abuse to the director of long-term care. And so whatever moral quandary Jeremy may have in terms of reporting or not reporting might be assisted by his legal obligation to actually report the abuse to the director. Eleanor and any other resident is not under the same obligation. And in fact, Eleanor might not regard the sexual activity as abusive because it's not clear that she lacks mental capacity to engage in that activity. The courts have, not to my knowledge, and I've studied it, clearly defined what it means for an older adult with cognitive impairments to be mentally capable of consenting to sexual activity. But they have given extensive judgments in criminal law proceedings about capacity in cases of drunkenness, mistaken identity, and that sort of thing. And what it really boils down to, in my view, is that the lack of consent under the criminal code involves a lack of understanding of the essential sexual element of the act and understanding what the act is. I don't think the criminal code has yet, the criminal law has yet developed to a point where capacity for consent to sexual activity involves an element of appreciation of reasonably foreseeable consequences. But there's lots of cases, for example, where a woman is drunk in a taxi cab and the taxi cab driver initiates sex with the drunken woman who, in the judgment of the court, lacks consent, or a common law couple on the verge of breakup is consenting in what would be otherwise consensual sex, but for the fact that the male partner has poked holes in his condoms for the purpose of impregnating his partner to preserve the relationship, in which case there was no knowledge of the actual nature of the act. The court has found that sexual intercourse with a condom is quite different than sexual intercourse without a condom. And so when we translate that to older adults with cognitive impairments, are they really understanding the sexual nature of the activity? Do they appreciate the person they're with? Maybe not by name, but do they appreciate that this person, what position does this person hold? It's not really their husband, or it is really their husband, or it is someone who, they understand their nation. So we can't draw conclusions about whether Eleanor is consenting or not consenting to this act. But what it is clear is that in the long-term care home context, as in other healthcare contexts, it is verboten for caregivers to be having sexual relationships with their clients or patients. And here, this is not necessarily a patient. We don't know what this caregiver is. Certainly, if it's a regulated health practitioner, that's a really big problem. And if it's an unregulated health caregiver, it's still a problem, but not of the same degree.
Yeah, these scenarios, it's not just the question of capacity. It is also a question of the breach of boundaries. In other words, can someone that is dependent on another person actually consent to sex? Can someone under the care of any healthcare professional, I think, as Graham pointed out, we have really serious problems. But someone that may be able to consent to sex in normal circumstances isn't able to do so when it's under duress. And the duress in this case is the manner in which the health care aide has been treating them. And that just completely opened up the ability to pursue sex through duress, which is not consensual.
And approaching it from the Eleanor perspective, as we do, if we were the ones to get a call from Eleanor asking for help with this, help in the means of legal advice, then our approach would be to meet with Eleanor in private, assure her lawyer-client confidentiality, and to seek instructions to pursue her remedies. Our advice to her would be that she is not under any obligation to report this abuse because she is the resident, but we would urge her to do so and help her develop a safety plan, steps to protect herself. And we do get calls like this. I mean, early on when I first started 30 years ago, one of our first calls was from about a man, a 55-year-old man who had a stroke in a Toronto long-term care home, who had been sexually assaulted in the shower by a male personal care worker. And his family only found out about this later on because he was so ashamed of it. And when they reported it to the home administration, they suggested the family and suggested they report it to the police. And the administrator said, no, we can't do that. We have to do our own internal investigation first. That's our policy. That's no longer the policy in Ontario. We have a zero tolerance policy. But our policy is you call the police on these things if we're acting for Eleanor, if Eleanor instructs us to do so.
Sometimes there would be one of the things I think we wanted to touch on is the role of Section 3 counsel. So this is in the if there were a proceeding under the Substitute Decisions Act underway here. So let's say that the scenario may be that let's say Jeremy has a sibling, so they're both grandchildren of Eleanor, and they're in a dispute with respect to whether it is safe for Eleanor to live there. Let's say they've already taken care of this particular scenario, but the suggestion of one family member is that she ought to move to another long-term care home, and they're in the midst of a dispute. And Eleanor is not represented in that dispute between the two grandchildren. That would be the scenario in which the public guardian and trustee might be asked, in the event that Eleanor is not represented by counsel, to make arrangements. And this is sometimes a delicate role. The role of Section 3 counsel is to advance not necessarily the best interests. Sometimes they do align, but the wishes of the alleged incapable person, and for the purpose of the proceeding, the alleged incapable person is deemed capable of retaining and instructing counsel. So this is intended to ensure that the wishes of a person alleged to be incapable in the context of a dispute are brought before the court. So if there is a case referred to where Section 3 counsel was arranged, and it happened to be in our office to represent a person alleged to be a victim of sexual assault by a much younger boyfriend who was visiting her in her home. And this can lead to many different, uh, none of them um, none of them ideal, but different obligations on counsel to ensure that the wishes of the person alleged to be incapable are brought forward, including the wish to have her own say about whether and when she has sex. So it's a can be a sensitive role.
And we would align with Marshall's comments on that because, aside from the caregiver relationship, it's not illegal or bad for older adults to be engaging in sexual activity unless they lack consent, lack capacity for consent. And more often than not, family members, caregivers are horrified that older adults still have sexual urges and demonstrate them, even even when they experience marginal capacity in other areas. And if the person still has, God bless them, the drive and desire for intimacy, and they have the mental capacity to understand the nature of the act and who they're doing it with, and the information about the act, then in my view, they may be quite mentally capable of making those decisions. And if it does not pose a safety risk, it's not the area of a substitute decision maker, because sexual activity is not an area of substitute decision making. In law, there can be no substitute consent to sexual activity. It can only come from the capable person, him or herself. And the substitute decision maker would have authority and safety decisions. And if incapable sexual activity forms a safety risk, then a attorney for personal care or a court-appointed guardian of the person may have decisional authority over the safety decision that involves the sexual activity.
One of the things that can also obviously be elder abuse that we haven't touched on significantly is that of financial abuse. And this is an area where the courts can be more effective. So in the context of a guardianship application, let's say there's an attorney who's alleged to be profiting from their role as an attorney for property. At the outset of a guardianship application, courts presented with sufficient evidence that there is financial abuse going on are in a position to grant injunctive relief to sort of ensure that properties that have recently switched, where a title has recently been switched or been put into joint ownership with in questionable circumstances, or bank accounts have become joint, or money seems to be funding vacations of an attorney. These different these things can be stopped effectively and early on in a proceeding through orders freezing assets, with ensuring, of course, that sufficient assets are made available to the alleged incapable person to ensure that they can get by without any material impact on their lifestyle. We have some questions that have been placed in the chat. The first one is, I think, pretty easy to answer. So, and that's the question about whether capacity assessments are admissible in court. So a capacity assessment might be ordered by the court, in which case the court is very much interested in the outcome of the capacity assessment. Otherwise, a capacity assessment is going to be evidence, opinion evidence. It's going to have to be presented in the normal manner with a statement of the expert's acknowledgement of the expert's duty. It's going to have to be presented as part of an affidavit so that it could be capable of being the subject of cross-examination. But yes, capacity assessments can make their way into evidence appropriately. Next, there's a question about the role of capacity assessors that they could fulfill in cases where an older person is in the middle of interfamilial allegations of abuse, and there's isolation of the older person by one of the parties, what might capacity assessors do in those circumstances? It's a difficult role, but I think that if one is exposed to the kinds of risk of significant harm or the serious adverse effects threshold, I don't think a capacity assessor has an obligation of confidentiality in terms of those kinds of things coming to their attention. And yes, the circumstances of isolation can certainly become part of the narrative of a capacity assessment report. Again, there might be some question about whether the person that's engaging the capacity assessor wants to pay for a report that documents the neglect or the isolation, but but I think capacity assessors can disclose and do something about what they see that is serious harm.
And the thing I'd like to add, Marshall, is of course that absent a particular role such as an assessment of capacity for capacity to manage property, which has a legally conclusive effect, capacity assessments are not legally conclusive documents. And what they really are is they're an expression of opinion on the issue of capacity. And if litigation is involved in any litigation matter, nothing is a fact until the court finds it to be a fact, whether it's by the presiding judge and a judge alone or by the jury. The court hears evidence and decides the facts. And I think there's sometimes a mistaken interpretation that when a capacity assessor says things in the report, those are essentially hypotheticals to be proven by evidence. If the capacity assessor says this person did that, that's not necessarily evidence that that person did that. There may have to be evidence of what the actual facts are, and that the assessor's opinion is predicated upon the facts stated, as with any other expert report. And
I would have one caveat. If when we're outside of court, were Section 16 of the Substitute Decisions Act assessment carried out, and someone doesn't have a power of attorney for property, then the public guardian, that will trigger a statutory guardianship by the public guardian and trustee.
Absolutely.
Subject to review by the Consent and Capacity Board.
Yes, and that is a legally conclusive finding, as is a finding of incapacity by a health practitioner for a treatment decision, as is the finding of incapacity by an evaluator for a capacity to admission to long-term care or for personal assistance services. There are certain defined instances where capacity assessments are legally conclusive. And in every one of those cases, there's an appeal mechanism or a review mechanism before the Consent and Capacity Board.
Graham, I fear our hosts are about to take out a big cane and pull us off the stage.
We're just getting warmed up, Marshall.
If this could be 3 hours, then I'd make it that. But we are unfortunately at the end of the hour now. I want to give a big thanks to Graham, Marshall, and Brad for speaking today. There's a reason we left this subtopic on elder abuse to the end, because we know the quality of the presenters and the seriousness of the topic. Thank you to everyone who has attended this seminar, who has attended the series throughout this year. We really appreciate it. And we wish to see you next year. We'll keep you updated about what that topic is going to be. Again, don't forget, we've downloaded the certificate of attendance in the chat, the papers, the Law Pro credits. So please take advantage of those before you log off. And to everyone, thank you again for attending, and have a great rest of your day.